Hello, this is Maria Mejia-Opaciuch, Senior Counsel at Carlton Fields, Jordan, Burt, PA. I'm located in their Miami, Florida offices, and this is December 2018. This is the third of 3 sessions that I have been presenting on regarding U.S. immigration policy and procedural changes impacting foreign students. This session will cover the topics that are found on this slide here: employment as a tenured professional in academia and employment as a professional staff member in academia. The reason I've distinguished the two are the fact is that for tenured professionals, when you're hiring them on an indefinite basis, and truly this presentation here will cover the residency process for individuals working in academia. And the first topic here is the tenured professionals, tenured professors, and then the second topic will be for those that are professional staff in academia. So I want to cover on this slide here what employers who are in academia looking now that there have been these recent policy changes and procedural changes and delays in the processing that I discussed in depth in sessions 1 and 2 is what employers will be looking at when they're hiring foreign nationals that have been here in the U.S. under the F visa, M visa, or the J1, and how they want to make sure that there will be no prior unauthorized work in the United States or unlawful presence in the United States that would subject them to either questioning about compliance, and if there are any periods of time that would trigger that 3-year or 10-year bar that I discussed at length in sessions 1 and then somewhat touched in session 2. So anytime that you're going to make an application and you reveal that you have been in the States in any one of these 3 classifications, the employers are going to, in all likelihood, be seeking legal counsel to review the eligibility for a residency in the United States. And again, I'm only covering for the most part here in this particular session, the road to residency in the United States and what they would be looking for if they're going to go down the road of a green card. Even for tenured professionals with that are being offered professorships, they will definitively be looking at any prior indiscretions as far as unauthorized work or unlawful presence. And then on the other side of this is what should you as a student who is in the United States working either under the OPT or EAD, and you're going to be applying for residency in the United States in the tenured professorship position. You want to make sure that you have a very clear outline of all your dates, your status in the United States, and any explanation of any discrepancies. You want to make sure again that you've looked at your CVIS records, you have them in order, and there is no gap in any program changes or even changes from one school to another. You want to be able to explain any discrepancies. Have that outline as part of your application if you're going to be putting in your CV. You want to make sure you have that. Either you put it in with the application or during the interview process, you want to make sure you're able to pull that out and have that ready for your employer to review. Also, it's incumbent upon you now more than ever with all of the administration's policy memorandums and executive orders and the president's new use of proclamations to make changes in the practices or in the procedural processing of any of these visas. You want to make sure you keep abreast of that. Visit the websites for CVIS. Visit the USCIS website regularly for policy memos, and keep abreast of USCIS announcements. You can sign up for email alerts of any announcements on any policy memorandums or any proposals that are going to affect students in the United States as well as the green card process. Now I'm going to discuss the hiring of professional staff in academia. And again, as I had said earlier, I want to make sure that you understand that There are tenured professorship positions that are available, and the processing for a green card is a far more streamlined process than it is for a professional hired in academia to work either as a researcher and or in administrative positions, management positions, those kinds of roles where you're not going to be filling a tenured professorship, but you would be working for the university in a professional capacity, in a specialty occupation, if it happens to be the H1B, or if you're going to actually have a green card processed on your behalf while you're still a student and working under the OPT timeline. Again, the employers are going to, the universities, academia, nonprofit organizations are going to be looking to see if you've had any prior visa overstays or any unauthorized work, unlawful presence. They want to make sure that you've been compliant the whole time and that there's no gap that would expose you to not being qualified, or to not being eligible for the residency. And once more, I recommend that anyone who is seeking employment in the United States after graduation, either during the OPT period or after that, that you have a clear outline of all dates, all your stays in the United States, explain any discrepancies, be able to show that if there were any gaps, that it was less than the period that would expose anyone to a 3-year or 10-year bar. And again, please keep abreast of any changes in the CVIS website, the USCIS website, USCBP. There are ways to sign up for alerts in these particular agencies' websites. Do so. They're quite good, the alerts, and they, even if you did not understand what the proposals are or what the policy memos mean to you and how they apply to you, once you know that there's something that has been announced that could possibly impact you, it is a good idea to always seek legal advice from immigration attorneys or even at the international student officers, advisors. You can, assuming you remain a student and you're in either student status or in a OPT period, you can seek their advice or guidance as to what any of these proposals could mean for you and your ability to stay in the country and work in the country. So when you are a professional staff seeking employment in academia, you still have to be able to meet the H1B definition and be eligible under their criteria. While there have been no changes actually in the laws or the regulations that govern H1Bs, what has changed dramatically over the last 23 months is the way the USCIS is interpreting and applying their interpretation to H1B petitions. In the past, it was relatively straightforward that if you had a degree in a specialty area and you were seeking to fill a professional or specialty occupation, as long as you were able to show that the specialty occupation requires theoretical and practical application of a body of specialized knowledge, along with at least a bachelor's degree or its equivalent, you were able to file for an H1B petition. The USCIS now has actually taken to listing on their website under the specialty occupation definition architecture, engineering, mathematics, physical sciences, social sciences, medicine and health, education, business specialties, accounting, law, theology, and the arts are specialty occupations. So what is occurring over the last few, I would say in the last 12 months, is a very narrowing interpretation of specialty occupation, in that most decisions now where there is denials or where they have issued RFEs, requests for further evidence, the Immigration Service now articulates the standard as a reviewing of both the INA, the Immigration and Nationality Act definition, as well as the regulations under 8 Code of Federal Regulations, 8 CFR, which discusses how to apply the statute. They are reading those 2 sections of the law and coming up with a conclusion that a specialty occupation is one where there is a position being offered that requires a specifically directly related degree to the occupation or the position. So if you hold a degree other than the one specifically related to the role, the H1B in all likelihood will be denied. So typically engineering positions have been classified as specialty occupations, and they will continue to be so. But if you are in a position that is that requires a degree but not necessarily a specific one related to the position, the H1B may be denied. So if you were, for example, a manager research analyst, and you hold a degree in a particular field like business administration, that may not necessarily be directly related to the role, and therefore the H1B may be denied. Very important now, more than ever, to get a clear reading of the duties of the job you are going to fill, as well as look at your degree and see if it is directly, specifically related to that field. Seek the advice of counsel, immigration counsel, so that you will be able to meet the now more narrow standard and interpretation of a specialty occupation. And it's also critical now in that the USCIS has been given the authority to issue denials rather than request for further evidence in their discretion. So if you do not meet this new narrow interpretation of a specialty occupation, you will not be given an opportunity to respond at all. You'll just, in all likelihood, receive a denial. Also, ensure wage levels are correct for the position. The Immigration Service has taken the position, for the most part, in certain industries, that if it's a level 1 salary that is being offered to you out of 4 levels, the level 1 is seen as an entry-level salary, and therefore they conclude that if it's an entry-level position, it cannot meet the specialty occupation definition. Again, it can be argued successfully that an entry-level position is, in fact, a specialty occupation, but it's important to note salary levels. The advantage of working as a professional within the university setting is that universities are not subject to the H1B cap, and they are able to get as many H1Bs as needed throughout the course of a year. There is no restriction on when you can apply, so it's easier to pursue an H1B in academia than it would be in the private sector. Should you decide that you wish to remain in the United States indefinitely after an H1B, it is conceivable that you could work for the public sector under an H1B while the private sector be pursuing a PERM, a labor certification application, through the Department of Labor, U.S. Department of Labor, on the road to a green card. So that is an option available to you. While I recognize it is difficult to locate or identify a private employer who's going to be willing to seek a green card on your behalf without you having worked for them, it is possible that while on an H1B with the public sector, you may be in a joint venture with a private employer, and that private employer may be able to offer you residency in the U.S. and pursue a green card. So that is an option available. Please always stay vigilant as to the dates that you are in the United States. If you are on an F, M, or J visa after graduation from or completion of a program, keep a travel log and all CVIS forms. Note your dates in and out of the United States. Also, even if you're seeking extraordinary ability petitions under a temporary work visa, the O1 visa, or you're seeking extraordinary ability for residency in the United States, Either way, on any of these visa applications, we'll want to see your record of stays in the United States under the F, M, or J visa. So again, it's always wise to keep a travel log, keep a chart of all dates in and out, your statuses, and any number of days in, number of days out. If you've changed programs and there was any gap, document the number of days if possible. Make sure your CVIS record is clean and correct. At this point, we are going to cover some questions, and I'll answer them in the order they appear here on the screen. And of course, if you have any other questions or issues that you wish clarified, please reach out to me. My contact information is found on this slide at the end of the presentation, and I'd be happy to answer emails or take any phone calls with other questions that are not covered here. I'm going to take each one separately. There are 4 of them. What should I tell a prospective employer if they ask me about my immigration history? Because this again relates to that log of travel, your chart of your immigration history in the United States. It's important now to compile, more than ever, to compile such a chart. Make sure you have your dates in, your statuses in the United States, your activities, any changes in programs, any gaps that occurred, if you had any reinstatement because of dropping out for a period of time. You need to be able to show that and explain that and have that in a chart. If you're questioned, it's always good to be able to have that, to present it to them, because I know a likelihood any employer would seek legal counsel's opinion before they continue with the process of either a work visa application or a residency green card application. Number 2, can you give examples of specialty occupations? Okay, again, I before spoke of the list of the typical specialty occupations that the USCIS recognize under the H1B, and it's typically, again, I'll read that list. It's architecture, engineering, mathematics, physical sciences, social sciences, medicine and health, education, business specialties, accounting, law, theology, and the arts. Those are typical specialty occupations. Again, take a look at the degree requirements for any of the positions that you would be looking to fill under the H1B or under residency, but obviously more under the H1B, which requires a specialty occupation. And then the government has on the USCIS website a discussion on specialty occupations that you can also review as foundation for when and if you are going to be interviewed to fill an H1B position. Number 3, should I be seeking employment under a work visa or a green card after graduation? And the answer to that really depends on what your long-term goals are, what your short-term goals are. Do you want more experience than you've gained while in the U.S. under OPT if working under the EAD? Or do you want to, after the OPT EAD, just go home and apply what you've learned here overseas or back in your home country? And if you are going to seek a temporary work visa, note the difficulty we are having with the H1B program and the administration's continuing narrowing of the definition of a specialty occupation. Again, I bring up the possibility of working under an H1B in the public sector in academia and having in tandem an application for a green card in the private sector. That is a possibility and one that can be explored with the guidance of good, sound immigration counseling. Number 4, should I travel out of the U.S. if I believe I may have had a gap in status in the past? No. Immediately, no. You must seek counsel where there may have been some gaps, a change of a program, a change in schools, change or a reinstatement where you, for personal reasons, health reasons, may have dropped out and now are going back and there was a reinstatement application. You need to really make sure that you are fully equipped with all the necessary information to make a sound decision as to whether travel is a good option or whether you should remain in the country. But do not travel without any counseling, whether it be through a private attorney, immigration attorney, or through the International Student Advisors offices, the designated school official. Seek counseling before you decide to travel. Any other questions, of course, again, please reach out to me. On this slide, like in the other two presentations, we've listed a number of resources that are available, and these are, of course, government agencies' websites, as well as private association for international educators, and that also provides a number of updates, any warnings, any practical tips. It's good to visit that site regularly, and your best resource typically would be of course, your International Student Advisor's office or the designated school officer. Again, we have a glossary here for you to cover all of the acronyms, as well as the different visa types that we've discussed in this presentation, as well as the other two. My contact information, should you need to have that for any reasons, please reach out to me via phone or via email. I'd be happy to answer any questions or clarify any issues. Thank you.